Indeed, my lord, it can.
Do you have the locus?
Pardon, my lord?
Do you have the locus?
Indeed, my lord, we have the locus.
You explain, so there are three parts.
My lord, I am representing PDL in the first and second issues, my lord.
What is PDL?
People for Digital Liberty, my lord.
All right. So this is a group of people for digital liberty. I'm presuming this is a non-government organization. It's a NGO.
Pardon.
What is the nature of this organization?
This is a civil rights organ, my lord. Just.
But is it registered?
Council seeks ignorance on this issue, my lord. But to address the earlier question, I would like to hold here that this is a matter of the PIL as well, my lord. That is why we have approached this honorable bench, and that is our locus.
It's a PIL. Private interest. But as far as I understand, Aurora Technologies has their own interest. Dr. AIU their own interest, PDL their own interest.
My lords, Aurora Technologies, as per my my lords, as per the PDL, I'm representing issues 1 and 2. That is what my contention would be in the second issue. That Aurora Technologies forms a part of the state under Article 12. Refractions that we see here. Pardon me for the lack of properness of the because it is daylight. You're able to see these, my lords.
Yes.
Now, metaphorically speaking, these are the predicted risk scores, high risk scores or low risk scores as per the. However, there is a taint in the lens of the prism. The refractions here, the light through this, it is not forming the refractions that it should have made. And my lords, addressing Article 19(1)(a) also briefly, although I would be touching it in detail further on. If a citizen like you or me who is aware of what is happening, of what will stop sharing our data. And this simple experiment shows the situation and the gravity of the situation right now, my lords. If my lords permit me, I would be dealing with my
First issue, right?
first issue, my lords.
14, 19, 1A and 21.
Indeed.
To life of interesting. I mean, how is
My lords, I would be dealing with this in 3 lines of submission. I would be moving on to that gradually as I move on from. There's a blatant. Three case laws, 3 tests, my lords. As we all know, there are 3 tests in the.
how it violated of 14.
But I would.
Basic thing. When you are reading it, you must tell the facts. These are the facts on which you have filed the petition.
Indeed, my lords.
And
My
then
lords,
go
if we
forward.
would open the page 7 of the Moot memo
Yes.
of the petitioners.
Yes.
Aurora Technologies was founded in Vienna by Arush and Dr. Kavia to create AI for urban utility management. Now, this company developed Civ IQ. This was their first
You
model.
asked us to move to page 7 for what? What are we reading here?
Statement of facts. 7 of our petitioners' memorial, my lords, not. If I may move on.
No, wait. You
Page 7 of
You have come under 32 and 423 of Companies Act.
Indeed, my lord. 423 is regarding the appeal matter, my lord, which has been clubbed by this Honorable Supreme Court. It doesn't relate to Aurora, Kavia, or PDL. It is relating to the minority stakeholders' appeal against BP80, my lords.
All right. They are represented by?
They are represented by my co-counsel, my lord.
Okay. All
Yes.
right. Please go ahead.
My lord, if we turn to page 8,
Hmm.
Aurora Technologies was founded in Vienna by Arush Mehta and Dr. Kavia Iyer, data ethics expert, to create AI for urban utility management. The company developed Civ IQ, a predictive platform for municipal governance, which attracted significant seed funding and led to its expansion. This is the crux of Aurora Technologies, my lords.
Right.
Then the PrismNet project and state partnership. Now, the government of Indica and the Ministry of Digital Affairs, they released a public tender for a PPP, and they selected Aurora Technologies based on their ethical design and their technological advancement designs in 5 pilot cities of Indica, and they implemented this model there. Now, internal ethical conflicts and board dissent, my lords. This is another development.
Before we move, what did this do? What did PrismNet do?
Basically, my lords, PrismNet is an AI, which, as I showed you through that experiment,
Leave that. We didn't get. Okay. I know what you were trying to get at, but
my lord, PrismNet is simply an AI which does behavioral profiling. How some parameters are fed into it, an algorithm is fed into it, and it analyzes that data based on certain factors, and then it gives out predicted risk scores.
all right.
If according to that AI, if some person is more likely to commit a crime, he would be flagged with high risk scores. And if somebody is likely, if somebody is not likely, or some place is not likely to be higher in crime, it would be flagged as low risk score, my lords.
Okay.
That is what the AI was doing, and
Right.
that was what the plan of the government of Indica was, to implement this to further supervise, my lords.
Yeah.
Now, there was in Aurora Technologies, what happened is Dr. Iyer repeatedly cautioned the board that PrismNet lacked rigorous audits and risked institutionalizing discrimination against marginalized communities, my lords. Between 2024 and 25, MODA issued strict instructions for Aurora to align analytics with policy priorities and share real-time data, threatening contract breaches for non-compliance. Despite Dr. Iyer's repeated dissent, the board voted 4-1 to comply with the government directives to ensure operational continuity and funding, my lords. Now, public criticism and corporate mismanagement. The next development here is that PrismNet faced backlash for disproportionately flagging low-income
Also,
neighborhoods.
you need not read from this. You need not read from this.
Indeed, my lords.
In one paragraph, see, my understanding that if you can explain in one paragraph your case, then you have a case, otherwise you don't have.
My lords, briefly speaking, before this honorable court here, there are matters of 3 petitions and 1 appeal matter. 3 petitions, namely PDL, Aurora Technologies, and Kavia Iyer, and the appeal matter by the minority stakeholders in the matter. Now, I am representing PDL here. I am alleging that there is a violation of Article 14, 19(1)(a), and 21 of the Indian Constitution by the PrismNet, which includes both Aurora Technologies
Because
and the state.
they have created an AI that analyzes people's behavior and puts them, and basically
Violates
it is
their
for national
fundamental
security,
rights.
right?
My lords, I would be advancing my arguments on the very same topic. If my lords are satiated with the facts, I would begin right away.
Please go ahead.
Indeed, my lords. My lords, there are 3 tests under Article 14. The first being reasonable classification and intelligible differentiation, as we all know. Where is the reasonable classification in this matter, my lord?
It is
Low.
for you to demonstrate that there is no reasonable classification.
I'm answering that very question, my lords. That dividing people into high risk score individuals and low risk score individuals is not a reasonable classification to make in the first place.
Why not?
And my lords, what are the intelligible differential in this matter is of major concern. What is the intelligible differential? The facial biometric recognition, the financial transactions, and the behavioral profiling. That does not in any other way relate to the rational nexus. It does not.
What is the rational nexus? What is the stated nexus?
As
What
per
is
them, the
stated
rational
objective
nexus
of
is
this?
national security, social welfare.
Yes.
But it does not, the two things do not match, and hence there is a failure, my lords. How can you look at somebody's facial features and say that, okay, this person is more likely to commit a crime? Or how can you tell by looking at somebody's financial transactions and predict whether or not they're going to commit a crime, my lords? This is simply not, my lords, I would be submitting.
But what the state is doing by these predictions, are these people put at risk in any manner? Are they
Indeed.
being detained? Or they are just being profiled?
My lords, but it is a huge attack on their right to privacy. My lords, I would.
Is that data made public?
My lords, that data was also leaked as per the clarifications, my lord.
Leaked by your client?
My lords, but that
Leaked by your client?
I'm representing PDL, my lord.
Okay, but the same side, right?
But no, we are forming a body of the petitioners, but we are not representing the same parties, my
All
lords.
right. But
Indeed.
it wasn't leaked by the state. It wasn't because that.
I would be establishing that Aurora is a part of the state, my lord, in my next issue.
See, there's a PPP, there's a private-public partnership. There's state, there's Aurora. All right. You may say that it is performing the state function. We'll come to that. But as of now, there has been no leakage as far as state or Aurora is concerned. A second.
There has been leakage, my lord.
By whom?
My lord, I am PDL. I am for me.
No, by whom? I'm asking. I'm not saying who you are.
By Aurora Technologies, my lords.
They have leaked it.
Yes, my lords.
Intentionally, they have leaked it.
My lords, that is irrelevant to the matter. The matter stays the same, that the sensitive information of the people of Indica is being leaked, is not safe. And my lords, it is not just related to what will happen or what will not happen. This is a direct attack on their sovereignty, the direct attack on their fundamental rights. My lords, what
Are
happens?
you aware of CIBIL score?
Of what, my lords?
Have you heard of the term CIBIL score?
Credit
Uh,
score.
Credit score.
Credit scores, my lords.
On the basis of
vaguely,
you get loan, you get the rate of interest.
yes,
and all
indeed,
that.
my lord.
All right.
Please, my lord.
That is also based on some certain profiling.
That is based on a financial realm only, my lords. This is a constitutional matter that we are talking about here, and it's a
But
fundamental
there is denial of
fundamental
there is
right
denial of
violation, my lord.
Right, you're right. You're absolutely right. Okay, you may be right, actually. But
Indeed, my lord.
all I'm saying is that there is profiling. The profiling itself does not make it illegal.
My lord, the effects that profiling is making, that makes it illegal.
Do you have any data to support that it is having that effect?
My lords, I do not have.
Do you have apprehensions or do you have facts?
These are not apprehensions, my lord. These are very reasonable. My lords, if you would just hear me out,
Yes.
I would be satiating, my lords. If we leave Article 14 for a while, if we talk about Article 19(1)(a), freedom of speech and expression, my lords. Now, I or you, as a rational citizen, as an aware citizen of the country, who knows that each and every movement that you're trying to make, your social media sentiments are also being analyzed to scrutinized to such an extent that you can be held as a high-risk criminal or an individual according to the government, then what would you do? You would stop expressing yourself. That is
So you're
self-censorship.
saying that it is having a chilling effect.
Chilling effect, my lords. Indeed. That would have a chilling effect which leads to self-censorship. Now, if for one reason or the other, directly or indirectly, if I'm unable to express myself, that is a clear violation of my rights, my lords. And it does fails all the tests that are laid out by this very honorable court, my
We have
lords.
come on 19 now. 19.2.
Please, my lords.
All right, 19.2 practically restricts a lot of right that is given in 19.1. This is being done for public order,
As they claim, my lord.
as they claim. The
Indeed.
stated objective
Indeed,
is
my
public
lord.
order.
Indeed, my lord.
That is an exception to 19.1.
My lord, but this is not falling under any of the reasonable restrictions. The actions are not falling squarely into any of those grounds that are provided under Section 19 Clause 2, my lords.
All right.
My lords, if I could just to revert to Article 14, I just have a very interesting concept that I would like to share with my lords. If we could please turn to page number 18 of the Moot memo. There's this thing called the confusion matrix.
thing called?
Confusion matrix, my lords, which happens with AI prediction. My lords, there is actual positive and there is predictive positive. It leads to a true positive, which, my lords, if I may beg for extra time. I've exhausted my time. My lords,
2 minutes would be enough.
my lords, I wouldn't be able to because I have second issue also pending.
You continue.
Indeed, my lordship, your lordship. So actual positive and predictive positive lead to true positive, which is fine. Actual negative and predictive negative lead to a true negative, which is fine. But the problem arises where there's false negative and false positive. What about these individual, my lords? This is the classification that I was referring to. These are either the safe people who are wrongly flagged as risky, or risky people who are not flagged as risky and treated as safe, my lords. What about these people? This is this is the classification that was not that is failing the test of reasonableness, my lords. And if I skim through due to paucity of time,
Yes.
I would be establishing that it fails the test of proportionality itself. My lords, under Article 1, Menka Gandhi versus Union of India, the very landmark judgment by this court which says, procedure established by law. My lords, PPP is not a law. If at all they had to pass this, they should have passed this through the proper course. They should have passed it through the parliament, should have followed the proper course of action, my lords. They are trying to slide it through a PPP, slide a law or a policy through a PPP, which is not a law at all, my lords. So it fails the test of proportionality as well as...
Wasn't this done under the DPDP Act?
My lords, it is in relation with DPDP, but it is acting as a law in itself, and it was not passed by the parliament. And PPP cannot be treated as a law by any stretch of
Is it by an
imagination, my lords.
executive order?
Sorry, my lords.
Is this creation of this PPP by an executive order? No.
My lords,
It's under DPDP Act only.
my lords, the Ministry of Digital Affairs entered into a PPP with Aurora Technologies, my
Yeah.
lords. And they are serving it as a law in itself, my lords. This policy is being treated as a law in itself, which is illegal in its first place, my lords. Also, I would like to highlight real versus ostensible object, my lords. The real versus ostensible object theory, it also fails because ostensibly their purpose is efficient governance, public order, social welfare, what all they are claiming. But the real purpose is political steering, my lords. In the Moot memo itself, it was mentioned that they are asking for sharing of the data in electoral districts. How is real-time sharing of data in electoral districts serving as social welfare or public order, my lords?
For better distribution of
My lords-
subsidies, for better distribution of benefits.
My lords, in
The
clarifications,
state
it
has
was
a right
mentioned that they are asking for sensitive voter data, my lords. And this is a clear...
You have an obligation, by the way. They will have.
in-
They will have.
My lords,
Matters are to be.
but what they are doing is not aligning with what they purported to be saying earlier, my lords. And if I move on quickly to the issue 2 due to paucity of time, I really apologize for not being able to argue at
No,
length,
no, you have
although I would love to. But
Counsel, we have heard you.
on issue number 2, my lord,
All right, briefly.
issue number 2, my lord. My lords, I would be making quick submissions in this matter. Please. Just these.
Sure.
My lords, Aurora Technologies must be treated as part of the state itself because it is high time that this honorable... pardon, my
You
lord?
have given only one copy?
I'm
Yeah,
sorry,
yeah.
my lord. It is the
Then we can share.
it is the usual practice that goes on in
It
Moot
is
court,
not
my
the
lords.
normal
We
practice.
are only supposed to bring one
Okay, okay.
copy each, my lord. I apologize for the inconvenience.
What is this? This is the National Campaign for People with Right to Information.
My lords, this is the notification dated November 2005, where I could not reproduce the entire circular in itself, but there's a reproduction of the said.
What does it say?
It says that every PPP must be treated as state itself under Article 12, 2005, and it has not been disputed, my lord. My lords, it is high time that this honorable Supreme Court sets
Are
a...
you aware of the BCCI judgment?
Indeed, my lord.
What does it say?
My lord, it says that BCCI was not a part of the state because it held its...
It laid down a test, right? It laid down test to
If it's
determine, see, it starts from Ajay Hasya. Ajay Hasya lays down the test.
indeed
ठीक है?
instrumentality,
With
functionality.
time, things change. The direction, the course that the country takes change. The
Indeed, my
modalities
lord.
change.
Indeed.
Then comes the BCCI.
Indeed.
That is the law on what is a state or what is not a state.
Indeed, my lord.
Okay. Is it performing a sovereign function? That is my question.
My lords,
And for that, I'm just adding to it. Justice Iyer evolved the test. There are 5 tests.
In-
Virtue of Soprakash Rekhi.
indeed, my
Yes.
lord.
And it was a constitutional bench. So if you go by that deliberation, the things could be easy.
My lords, if I might submit, even private bodies can be sued for mandamus. But
not?
I would be still bringing it under the ambit of Article 12.
Tell me something. If Aurora is retaining intellectual property rights as per the compromise,
It is indeed.
okay, and autonomy, it retains autonomy. Does that not weaken your argument that it is state?
My lords, it might be retaining its autonomy in certain ways, but there were 3 main areas where the autonomy was to be tested, which is financially, functionally, and administratively. And all of these areas have been hugely controlled and impacted by the government, my lords. As we would see in the notification itself. My lords, the lack of legislation or the lack of judicial precedence in this matter, my lords, is the exact reason why people...
There was deep and pervasive control.
Yes, indeed, my lords. The repeated circulars, the internal memos as written in the prop itself, paragraph 9, paragraph 11, paragraph 15, they were repeatedly asking Aurora Technologies to behave in a certain way which did not align with the ethical guidelines at all. My lords, it is high time that this honorable court comes up with a landmark judgment which brings all the PPPs under the ambit of Article 12, my lords. It is high time because people using the liberty of being under a PPP are using it to evade off their liabilities completely, my lords. This has been highly misused, and it has been so many years since this has been happening. And I submitted the circular in 2005, my lords. This 2026. So there is a high need of a landmark judgment from this honorable court itself, my lords.
You need a landmark.
My lords, because PPPs are highly unregulated, my lords, and this is exactly why it's been misused to evade off liability, my lords.
Thanks.
It has been a pleasure arguing before this court, my lords. I apologize if there was any rush on my part due to paucity of time. I could have argued at length, but my co-counsel would be handling the rest 3 issues now, my lords.
Permission to approach the time.
Yes, please.
Much obliged, your lordships.
Who are you representing, counsel?
Lordships, I am representing 3 parties in total. I've been delving into the constitutionality of EPDP Act, which is being challenged by Aurora Technologies. The second would be the arrest of Kavia, the legality of arrest, which is challenged before this honorable court. And the last would be the appeal matter under 423 of Companies Act.
No.
Indeed,
You are
Lordship.
challenging the whole of the act or certain provisions of the same.
Lordship, we are challenging certain provisions. In the course of my arguments, I'll be highlighting the
Then
provisions.
you should highlight those provisions.
Indeed,
You are-
Lordship. Indeed, Lordship.
challenging.
Now, the Lordship, with the permission of this honorable bench, I'd be highlighting the cause of action, the para through which the cause of action for third issue arose.
But before you do that,
Indeed, Lordship.
we're presenting all the 3.
Indeed, Lordship.
Right.
In separate matters. Indeed, Lordship.
So how are you before us in 32 over an arrest?
Lordship, we have invoked the writ of habeas corpus, Lordship.
It can very well be raised before the High Court.
Lordship, it
No,
could
not
have,
just that. Not just that. The person has been arrested. You know where the body is.
indeed, Lordship. However, Lordship, it is to be noted that habeas corpus can be invoked where there is a case of violation of Article 22. That is to say, there has been a case of illegal detention.
Are you not arrested? Are you detained or are you
The
arrested?
first question
He
is,
has
you have
been
been
arrested under some statute.
Lordship, we are arrested under statute. Lordship,
Then
further, we
How
are being
does-
detained
how
as
does
well.
habeas corpus lie here?
Lordship, by the clarification of para number 11 and 12,
Yes.
Indeed, Lordship. Now, in absence of such, Lordship, if you may have it, I may have you on the same page. Lordship, in absence of such material, fact, Lordship, we are pressed to invoke the habeas corpus since we do not know the whereabouts and we don't know the investigation as well as the trial status
No,
of the petitioner.
wait, the
Where he has been
clarification.
arrested?
Lordship,
Where he has been arrested?
Lordship, that has not at all been invoked. Lordship, further
No,
in
no,
the
no,
course
no,
of my
I'll tell you.
Indeed, Lordship.
The clarification really says with regard to the period between Dr. Kavia Iyer's arrest and the filing of the petition before the Supreme Court of Indica, it is clarified that she remained under arrest during this intervening period, not detained, arrest under law. However, the Moot position does not provide any details regarding the status or progress of trial proceeding against her. We are not even concerned with the progress of trial.
Indeed, Lordship.
We are concerned that a person has been arrested under law, okay,
Indeed, Lordship.
and have been arrested under which act? Under the National Security Law.
Lordship,
Okay.
three acts, Lordship. Official Secret Act, as
Official
well as
Secret Act,
BNS,
right,
and
And INS and UFPA
Indeed, Lordship.
is under the law.
Indeed,
You
Lordship.
should move a bail. Or you
Lordship.
should go for question. How are you before us in 32?
Indeed,
And
Lordship.
how is the habeas corpus maintainable?
Indeed, Lordship. Lordship, I'll be answering this honorable bench, the questions of this honorable bench in three submissions, if I
Okay.
may. Indeed, Lordship.
I would
Lordship,
prefer in one submission if you can answer this.
indeed, Lordship. Because, Lordship, the FIR, the contents of the FIR, the penalty, the attraction of these clauses are prima facie not made. And the
Are you
arrest itself,
challenging UAPA? Are you challenging
the
INS?
arrest under the attracted
You're not
provisions.
challenging the provisions of UAPA or INS.
No, Lordship. We are challenging the arrest. Lordship, the dictum of issue 4, which reads as under whether the arrest of Dr. Kavia is legally valid. We are challenging the arrest itself, Lordship, not the provisions. The provisions we understand, Lordship, 43D of UAPA Act, 43D as well as subsection 1 of UAPA Act,
Right.
43C, Lordship, we submit.
Right.
However, Lordship, these clauses, these penal clauses are not at all attracted. The prima facie ingredients.
They are not attracted. That is a question before the remand court. That is a question before the court where you move the bail.
Lordship,
Under 32, how are you here?
Lordship, simply, Lordship, since the arrest is shrouded in mystery, the process of arrest is shrouded in mystery, we do not know whether the mandate under Article 22,
What is your prayer?
Lordship, we
As
want
far as Dr. Iyer is concerned, what is your prayer?
immediate release, Your Lordship, immediate release. Lordship, because, Lordship, in absence of the material facts, what we are alleging here, what
are the parameters on the basis of which you can say that a particular arrest is violative of certain parameters set forth by the Honorable Supreme Court in various cases?
Indeed, Lordship. Lordship, I'll be quickly referring to K and Najib case, Lordship, in which three things were to be decided.
Yes.
Pre-FIR, the charge sheet, as well as post-FIR, post-charge sheet, Lordship. These are the three things which needs to be taken into consideration. Lordship, now we are alleging that,
Yes, Najib case was an SLP, not a rate.
indeed, Lordship, it was the SLP, Lordship, because the bail was denied at the High Court,
Yes.
Lordship. Indeed, Lordship, we are aware. Lordship, further, the reason we are invoking it is because the entire process, be it with respect to arrest, be it with respect to 24 hours, Lordship, be it respect to Article 22, Clause 2, the mandate, the Lordship, the mandate, the day's mandate, Lordship, those are not at all followed, which is what our prayer is
If
as well.
you can get the bail, that will amount to restoration of the corpus. You will get the same relief for which you are here.
Lordship, this is
If
where,
you apply for regular bail
indeed, Lordship,
and you get the bail,
Lordship,
that relief would get amount to this, to which you are seeking before us.
Lordship,
You are seeking special indulgence.
indeed,
You will
Lordship.
Why
have
should
to
we
show.
give you special indulgence? There is no
You will have
no
to
case
show
made out for
that
that.
there is no efficacious relief which you can claim from any other court.
Indeed, Lordship, if I may answer to the
Yeah.
query of this
When the
honorable bench.
remand would be produced, you are having a right to apply for bail. Even the magistrate is having powers under the old as well as the new CRPC to even to refuse the remand.
Indeed,
and to
Lordship.
release and to set you at liberty.
Lordship, firstly, Lordship, there are Lordship, two lines to this. Firstly, that exceptional circumstances called for exceptional measures. Since bail was denied by the High Court consistently, Lordship, and therefore the fundamental right was also compromised of Dr. Kavia. Lordship, these are the submissions with respect to issue 4. I have not yet made submissions with respect to issue 3 and 5. Please.
You need not go in the sequence that is in your head.
Indeed, Lordship. Now, Lordship, exceptional circumstances warrant exceptional measures. This is an exceptional measure because arrest under UAPA, the prevailing law is that bail is the exception and jail is the rule. Now, since jail itself, the arrest itself is illegal, the arrest itself is not warranted at all. How is the detention or arrest?
Counselor, I think you should move to your next argument because again, you are not here before us for bail. You have not filed. You should go to trial court, to the session court and file for bail.
Lordship, again, Lordship, the state has not given us proper information whether or not trial is going on, whether or not fair trial, the principles of fair trial are
Are
going
you
on.
aware that a person is arrested?
Indeed,
If a
Lordship.
person is arrested, you have a right to seek bail.
Indeed,
You
Lordship.
know the provisions under which he is arrested. You are aware of the FIR.
Indeed, Lordship. Lordship, since bail is consistently denied, Lordship, this is why we are
So
invoking
it
it.
is, if it is consistently denied, will you come in 32?
Indeed, Lordship, because fundamental rights of the petitioner are
You
violated.
can
No.
even come to this court after the rejection of the bail by the High Court.
Come in SLP. Why will you come in 32?
Why this 32?
If we
You are
reject
not
the
following
bail in
the proper
SLP, will you
jurisdiction at all.
file a 32 against that?
Lordship, it is just that this honorable court has jurisdiction.
We are having a remedy. It doesn't
Indeed,
mean
Lordship.
that this court is having a jurisdiction.
Indeed,
It
Lordship.
is like that. If I'm having a armed license, it doesn't give me a right to shoot also.
Indeed, Lordship. Then again, Lordship, further considerations to the situations and circumstances which warranted the arrest, it is submitted that this offense relates to national security. And since under national security, Lordship, these provisions, which are again, Lordship, it is submitted that falsely attracted, the liberty of which the petitioner, the liberty of petitioner is at stake. And Lordship, it is fundamental right of this of the petitioner under Article 21 as well as Article 22. That is what is an honorable submission, Lordship, humble submission. That is
21.
indeed, Lordship.
Say Article 21.
Indeed, Lordship.
What is Article 21?
Right to life, Lordship. Right to
What
life
does
and
it
personal
say?
liberty.
What does it say?
Lordship,
By the cannot be taken except by
procedure established by law.
Established by law. And
arrest-
what is law?
Lordship, now where there is misapplication of law, Lordship, misapplication of procedure, where is the petitioner supposed to go if not to the Honorable Supreme Court?
to session court for bail.
Session court for bail.
Lordship, this is
And
what
then
the
to High
submission
Court.
is, that bail has been granted, has not been granted consistently,
Have you
Lordship.
filed for bail?
Lordship, we have, Lordship.
Where does it say? you filed
Lordship,
for bail?
this is where the mystery clause, Lordship, in absence of circumstances, and since we, Lordship, this is not at all at measuring hearing. The Honorable Supreme Court has already admitted it. Now, this is a,
So we can always go back on that.
indeed, Lordship,
Issuing notice does not bound us that we are now going to hear this matter. We can dismiss it right away.
indeed, Lordship, it is well within the power of this Honorable Court to dismiss this right away. However, Your Lordship, the petitioner is just pressing for her fundamental rights. I am pressing for her fundamental
I
rights,
think you should
Lordship.
move on to your second act.
Indeed, Lordship, so far as in my humble submission, so far as the attraction of these penalty clauses, these penal clauses are concerned. Lordship, now, again, Lordship, with respect to Article 32, the proposition also is very clear in the paragraph number 24, Lordship. It is the fact as well. Now, coming on to the attraction of these penal clauses, Lordship, the basic, there would be a common submission, Lordship, owing to the paucity of time. Now, the first and foremost ingredient that needs to be met here is the intent, Lordship, the ingredient of intent. Lordship, intent cannot be established via observation of facts, Lordship. In paragraph number 21, there was only a leak of internal communications as well as audit reports, Lordship. It did not include any sensitive data or any raw data which could be attracted, which could lead to attraction of these offenses that are mentioned in the Official Secret Act, as well as INS and UAP Act. Lordship, what is sensitive data, Lordship? I'd be drawing an analogy, Lordship, with the submission. Now, Lordship, it is submitted that the sensitive data is governed by SDPI rules of 2011 under the IT Act, Lordship. Now, Lordship, if you may turn to Rule 3, which defines what sensitive data is. And if you may observe paragraph number 21. Lordship, now none of the clauses of Rule 3 are revealed under paragraph number 21. No financial information, no bank information, Lordship, no facial or biometric information. Lordship, the only reveals are under 3 clauses, which are government requests, instruction for unrestricted access, and board disagreements. These are not at all sensitive data, and therefore prima facie ingredient which should be met here, the intent, it cannot be established at all by any state of imagination. That is one humble submission. Therefore, the common submission, so far as issue 4 is concerned, it is submitted that the provisions, the penal provisions which are attracted before this honorable court, in this honorable court, they are not at all met. The prima facie ingredient is not at all met. And therefore, Lordship, the arrest is not at all legal. Indeed, Lordship. So this was my submission with respect to issue number 4, Lordship. Now, if I may address issue number 3 with the permission of this honorable
What is the
bench.
issue number 3?
Lordship, it deals with the constitutionality.
Of EPDP.
Yes, Lordship. Lordship, if I may be granted liberty to address EPDP Act as DPDP Act.
Why?
Indeed, Lordship. Please, Lordship.
Call it by the name. Why do you want to
EPDP
change it?
Act it is, Lordship. Much obliged. Lordship, it could have been a slip of tongue, Lordship. That is why I seek permission. Much obliged, Lordship. Now, Lordship, before I advance on merits, Lordship, there are some preliminary submissions that this honorable court, the council pleads a moment of indulgence, Lordship. Much obliged, Lordship. Lordship, the gravity of the situation can be understood by the conflict of two laws and two rights. The first is right to privacy and the other is right to information. Lordship, the first challenge under which we have come to constitutionally challenge this EPDP Act is the validity of section 44 subsection 3, Lordship.
What does that say?
Lordship, it amends RTI Act section 81J.
Okay.
Just for common observation of this honorable bench, the previous position was that 81J, under 81J, the public official had to reveal every information except those information which is of no use to of public good, Lordship. That is to say that if I get the chair and I'm a public official, I have to reveal every information except those which are too private for me and not usable for public good, Lordship.
Is that a primary argument on the constitutional challenge to EPDP?
Lordship, this is constitutionality challenge because via section 44 subsection 3, it has retrospectively amended RTI, a key sunshine law, as Justice A.P. Shah himself called it. Lordship, it has retrospectively amended section 81J and used the word personal data. Now, this personal information, which is also section 2 clause 3 of EPDP Act. Now, this very act defines what personal data is. Lordship, it is complete arbitrariness.
In Putuswar,
Indeed, Lordship.
advice also.
Indeed, Lordship.
Parliament does have the plenary power to frame laws for the protection of data,
Indeed, Lordship.
right? That is what the Parliament has done. Only personal data they have protected. Shouldn't personal data be protected? What is the mandate of Putuswami?
Lordship, right to privacy is now a fundamental right.
Right. So when it is a fundamental right, does a Parliament not have the power to legislate to protect that personal data, to protect that privacy?
Lordship, if I may
And there
answer.
is another very important question. You cannot ask anything under the government on one side, and on the other side, this EPDP, if you go by the deliberation, it is very much clear, that Swami rightly said that it is a fundamental right. The gravity is there. But, laws cannot be made to punish common people.
Lordship, now, since this honorable court posed me two questions, I'd be
Do you
advancing.
think that it progresses misuse?
Lordship, this is what the contention is, Lordship. Firstly, Lordship, the legislative competence is not at all challenged. We are aware that 7th schedule, list 1, entry 97, read with article 248, gives the legislation complete legislative competence to legislate EPDP Act. That is not at all vitiated. However, Lordship, what is vitiated? Now, coming on to his Lordship question, how it is being misused. Lordship, it is not at all being used properly at all. That is what the misuse is. It is not at all hiding the personal privacy of common citizen. It is hiding the privacy which is of public official. Now, public official are also covered under RTI Act, and they have to reveal certain information in light of the RTI Act 2005. If what is going to be revealed is shrouded, then RTI Act cannot function. Just for an example, Sheikh Lordship, if person X assumes a public office, Now, before his assumption of public office, he needs to maintain certain disclosures. Now, this disclosure is essential for maintaining
Are
transparency.
those disclosures were made to the public or the appointing authority?
Lordship, these are made to the appointing authority. However, public may ask by application of Section
That's
8.
Section 8.
When public interest warrant.
Indeed, Lordship, this is precisely the word used, when public interest warrants. Lordship, now if we completely negate it, that this person does not need to disclose personal data at all, which is what is done by Section 43, subsection 3, then Lordship, how would RTI Act function? This would inevitably violate Article 19(1)(a), right to information of the people. And there is this misjustice. Because one right is given precedence over the other. And it is well settled that both of these rights need to be balanced, right to privacy vis-a-vis the right to information.
But the unamended Section 8 also did not give you an unfettered right on information.
Indeed, Lordship.
RTI, I'm talking about the RTI Act, the unamended Section 8 also did not give you an unfettered right on information. This amendment only protects the personal data.
Indeed,
It
Lordship.
does nothing else.
Indeed, Lordship. Lordship,
What is the harm that is caused?
Now,
What is
indeed,
the
Lordship.
injury that is caused?
if your Lordship may observe, in the previous regime as well,
And also cover how it is violative of Article 19.
Lordship, that would be the application of test of proportionality. I'd be coming on to that after I answer your Lordship's question. Lordship,
Let me first answer this.
indeed, Lordship. Lordship, Article 19(1)(a) is infringed because the application of test of proportionality leads us that neither there is this safeguard nor is there any balance, and lastly, there is no necessity of such an amendment to RTI Act. The legitimate aim of this Act, EPDP Act, is mentioned in preamble of the Act. Lordship, if I may be permitted to have a sip of water.
Yes.
Much obliged, Lordship. Much obliged, Lordship. Lordship, now the application of test of proportionality, the 5-prong application, legitimate aim is mentioned in preamble. That is to say, the right to information, right to privacy, and right to data processing. They are all balanced. This Act claims that it is aiming to balance it. Now, the rational excess is the object should be to secure this right. However, the necessity of it is exempted, Lordship. The exemption, the sweeping exemptions under Section 17, read with Section 37 of the Act, Lordship, in which central government has been granted so many exemptions. Lordship, RTI is in this very sense compromised. And if we read how it balances Article 19(1)(a), Article 21, Lordship, if we remove the right to information, that is to say the amendment to Article Section 8(1)(j), and apply Section 43, that is to say personal data, then Lordship, it is shield.
Is personal data defined?
Indeed, Lordship, Section 2, Clause T of EPDP Act. Lordship, any information that can be discerned, identifiable of an information. Section 2, Clause T, Lordship, of this Act, EPDP Act, Lordship. If this person can withhold any information that relates to his person, then how would RTI Act function? Because it warrants that some disclosures are to be made for compliance of RTI Act. And therefore, in this way, RTI is violated and RTP, right to privacy, is given precedence. Lordship, and the balancing test, this is what this was the submission with respect to test of proportionality. And Lordship, now with respect to what your Lordship's question was, Lordship, the earlier regime, Lordship, coming back to the earlier regime, it warranted, again, Lordship, although I'm going in circles, Lordship, it is to be noted that earlier regime balanced. The earlier regime was actually balanced.
What earlier regime?
Section 8(1)(j, Lordship.
For amendment.
Before amendment, it was actually balanced because the information that should have been withheld was withheld. The information which related to actual privacy, which are of no use to public good, was actually withheld. But the information which was for public good, Lordship, I seek an extension
Yes. And
of
we-
5
I
minutes, Lordship, to
specifically-
cover all the issues. 2 minutes, all right.
We specifically wanted to deal with the 241 now.
Indeed, Lordship. Lordship, there are,
Mismanagement and operation.
Lordship, if I may,
Move to this. Let's.
Indeed, Lordship, just passing reference to all the challenges that I wanted to argue. Lordship, the excessive delegation, The DCI, which has leveled 950 crore, Lordship, it is excessive in nature, Lordship. It is again arbitrary in nature. Now, this is also done because Section 17 as well as Section 37 gives central the complete power to control and appoint DCAI in this matter, Lordship. Excessive delegation, there is no essential legislative policy. That is my submission. Again, Lordship, coming on to another challenge, that would be the crippling of RTI Act that I already dealt with, and the overall vagueness of the personal data, definition of personal data itself. Lordship, it only says any information of the person identifiable. Lordship, it is very vague, Lordship. And so far as the application and exercise of RTI Act goes, this is in complete contravention. Now, moving on to 241
How
issue.
it is vague?
Lordship,
How it is vague? It is as clear as anything.
Lordship,
Any information with regard to anybody.
Lordship, it is vague in the sense that,
What it says?
Lordship, if I may direct your attention to,
Yes. What it says, the definition. to which
indeed,
you are
Lordship,
referring.
if I may direct your Lordship's attention
Yes.
to Section 2, Clause T
You just
of
read
the
out.
DPDP Act.
Read it out.
Indeed, Lordship, it says, means any data about an individual who is identified by or in relation to such data.
Then
Lordship,
what-
now,
what is
by-
ambiguity in it?
Lordship, using the same definition, they are making it a shield
It's not
for.
vague, it is a wide definition.
Indeed, Lordship, it is
How
an
you-
overbroad
You are
definition.
saying it is very vague.
Indeed, Lordship, it is a overbroad. Lordship, not only it is broad, it is overbroad, Lordship, and it does not specify which. For example, Lordship, I submitted SDPI rules, Lordship, in which sensitive data was already defined. What includes sensitive data? This act ought to have done that, but this act did not do that. That what
It
constitutes.
says any data.
Indeed, Lordship, this is what this is where the overbroad application is. It should have specified it so other acts could also function. Lordship, I seek extension to argue the fifth issue. I'd quickly deal with it in just 2 minutes. In just 2 minutes, Lordship.
One-
1 minute. Last issue. That's it.
Indeed, Lordship. Lordship,
quickly.
the cause of action arises in paragraph number 19 of the Moot proposition. There was this order passed by BPIT.
Para number?
Paragraph number 19, the cause of action. Lordship, it has to be read in light with paragraph number 17 as well. Now, both of these would, indeed, Lordship. Now, the allegations that the question that before this honorable court is that whether or not there has been commission of mismanagement and oppression. Lordship, I'd be quoting the judgment of V.S. Krishnan versus High Tech Hospital, Lordship, in which the 6-pronged test for oppression was devised. And Lordship, our contention is that not only is it wrong, burdensome and harsh, but also there is an intent to do away with shareholders' interest.
Answer one question.
Indeed, Lordship.
My side. If the board acted under the government or directives,
Indeed, Lordship.
how is it operation?
Lordship,
How do you establish operation under 241? If the board acted under government directive, how is it an operation?
Lordship, this needs to be understood in the light whether or not this act, very act, causes prejudice to the shareholders.
You will have to know what is operation and mismanagement.
Lordship,
Every act, every resolution may not be termed as.
Indeed,
operation and
Lordship.
mismanagement.
Indeed, Lordship.
When the management is doing something under the aegis of any direction, law, statutory provision, how that act may be termed as operation and mismanagement?
Lordship, for that, I'd be referring to that in order to test whether or not an act by the board comes under the purview of operation and mismanagement, there needs to be certain criteria. Lordship, again, Lordship, just to answer your Lordship's question. Indeed, Lordship, just 2 minutes, Lordship.
Yes.
Lordship, the 6 questions that should be before this, that needs to be answered before this honorable court is the harsh, burdensome and wrong conduct, Lordship, which is what is here. Lordship, if we go to paragraph number 1 and 2, in which the intentional initiation of this company laid down that this would be compliant to ethical safeguard as well as operational sufficiency. Now, by complying with PPP, what they have essentially done is they have themselves contradicted the operational efficiency as well as the ethical compliance, because they have not at all ethically complied. And this very decision of ethical compliance was also in question in paragraph number 11, in which the CFO was also fearing the rights of minority shareholders. Therefore, this act, prima facie, ex facie, wrong. This qualifies the first test. Now, owing to the malified intention, Lordship, this whole regime, this whole operation of prison net by the board, the passing of resolution, Lordship, it shows commercial interest. The 200 crore allocation budget, 200 crore budget allocation, Lordship. It shows malafide intention. It shows commercial intention. Moving on to against probity, Lordship, when they're not including shareholders in their ethical compliance decision, it is the right of the shareholder. Then it is again against probity and good conduct of the company. Again, Lordship, legal permissibility. Lordship, this prism net led to a far huge and crying minority shareholders as well as other shareholders. Lordship, further, Lordship, it is just submitted that it is mentioned in a memo. Other tests are also followed. So far as the question of mismanagement is concerned, this honorable court in Tata Consultancy versus Cyprus Investment judgment, very locus classicus judgment on mismanagement, laid down that there needs to be two things: the cause and effect test. The cause test is whether or not there has been a change in management, and the effect would be whether or not it prejudices. Such a change in management is understood because for incorporation of PPP, we need to make an amendment to MOA. And there is a change of management. Now, what we need to establish here is the prejudicial act. This act of passing resolution under paragraph number 11 prejudices the interest of minority shareholders. It does not include them at all.
Is there financial detriment?
Any Lordship?
Is there financial detriment to the minority shareholder?
Lordship, financial detriment, Lordship, since the company is now at huge and cry and it has suffered through severe criticism, there is a financial risk.
Okay.
All right.
Thank you.
Lordship, if I may press for prayer.
Sure.
Much obliged, Lordship. In the light of the factual matrix, arguments advanced and authorities cited, it is humbly prayed before this Honorable Supreme Court that it may declare that the behavioral profiling is violative of Article 19(1)(a), 14, 21. Secondly, that Aurora Technologies indeed performs state functions and is liable under Article 12. Thirdly, to declare that EPDP Act and the provisions which are under challenge are violative of constitutional principles. Fourthly, that arrest of Kavia is illegal. And fifthly, Lordship, pass remedy under Section 242 of Companies Act 2013. That is what is humbly prayed before this honorable court. It was a pleasure.
That is a very British thing to do, very unnecessary thing to do also.
I know we are taught like that to do all this in moot court, but it's very unnecessary. Don't.
It was pleasure arguing before this honorable bench. I rest my case. Lordship, if I may ask the help of my researcher to carry my stuff.
Yeah, sure. Please, please, please.
Yes, please.
Greetings to the Honorable Bench. The Council seeks permission to address the bench collectively as your Lordships. Much obliged, your Lordships.
You are appearing for the union.
Indeed, your Lordship. This is the first Council appearing on behalf of the Respondents, Union of Indica and Aurora Technologies Private Limited in the lead
You are
matter.
appearing for both.
Indeed, your Lordship, in different issues. The Council first will be addressing issues 1, 2 and 5 and the Co-Council will be addressing issues 3 and 4. And because on the discretion of this Honorable Court, the petitions have been clubbed, the Council is appearing on the behalf of both Union of Indica and
In your
Aurora
memo, did
Technologies.
you raise a objection to the jurisdiction of this court?
No, your Lordship.
You are not taking this objection that this court does not really have a jurisdiction and they should have moved to High Court?
No, your Lordship. The maintainability has been put aside in this. It has not been raised as an issue
So you are
purpose.
not raising that.
No, your Lordship. Your Lordship, if your Lordships are well versed with the facts of the case, may the Council proceed with the issues at hand?
Sure.
Indeed, your Lordship. So, as already stated, the Council 1 will be addressing issues 1, 2, and 5, your Lordships, and the Council 2 will be addressing issues 3 and 4. Proceeding with issue 1, your Lordships, that is whether Prisminet's profiling violates Article 14, Article 19, Clause 1, Subclause A, and Article 21 of the Constitution of India.
Yes, please continue.
Yeah, please.
Obliged, Your Lordship. Your Lordships, in the submission of first issue, it is humbly contended that Prismnet is in no manner violative of Articles 14, 19, Clause 1, Subclause A, or Article 21, Your Lordship. Your Lordship, Prismnet is not an instrument of oppression. It is an instrument of governance.
Does your risk scores affect marginalized communities disproportionately or not?
No, Your Lordships, these are mere allegations which have been raised. There are no sound proof which show any direct conviction or consequences of these risk scores. Moreover, Your Lordship,
If
Prismnet,
you're putting the instructions,
indeed, Your
like
Lordship.
say facial features,
Indeed, Your Lordship.
how are you, I mean, give me an example. How are you telling this AI to recognize someone through facial features and profile them? What are the facial features that you're targeting?
Your Lordship, the facts on the proposition are silent on this, and the council contends that facial features are not taken as the sole factor on profiling the.
Name,
Your Lordship, names are not cited as
identity
a.
markers,
In what?
identity markers.
Indeed, Your Lordship, these are the group of factors which are taken into consideration while profiling a person. But Your Lordship, the council again contends that none of these factors are in any way discriminatory or targeting any particular marginalized sections of the society. These are mere allegations which have been raised against Prismnet, which the council humbly contends. Your Lordships, may the council proceed with the arguments?
Okay, so the Prismnet, I'm just reading from the document. The Prismnet project was launched in October 2023 across 5 pilot cities, namely Herat, Waila, Petrovi, Vienna, and Niseba. The system utilized advanced AI algorithms integrating facial recognition, financial transaction monitoring, social media sentiment analysis, and behavioral profiling. All these are could also be identity markers.
Indeed, Your Lordships.
Say, for example, a particular group is dissatisfied with the government of the day, with the power that be. You analyzing that?
Your Lordship,
And this analysis obviously has an effect, has a consequence. You are not analyzing just for the data. That is not a job of the government. You want to do something with it. You want to curb that. Right? You want to curb the sentiment of disaffection against your government. Is that not true?
Your Lordship, the council begs to differ on this issue because on this point raised by the Lordships, because the purpose of your Lordship, the purpose of Prismnet, as explicitly stated in paragraph 3 of the Moot proposition, if your Lordships.
Can you please tell us the object of it?
Indeed, Your Lordship, coming to that.
Paragraph number 5 is not explicitly conveying the purpose.
No, Your Lordship, paragraph number
It only
3.
says that AI generated predictive risk scores for individuals and groups, which were then communicated to law enforcement and welfare agencies to inform their decision. What decision? For
You
what
know-
purpose?
Your Lordships, if you may kindly refer to paragraph number 3 of the proposition.
Yes.
Your Lordship, it clearly says that Prismnet was capable of analyzing citizen data on a massive scale to predict potential criminal activity, optimize social welfare distribution, and assist law enforcement.
It shows its capability.
Indeed, Your Lordship.
It can do something.
Indeed, Your
Why
Lordship.
you are collecting this data? What is your object?
As Aurora,
Yes. What is the purpose of collecting this data?
Your Lordship, the purpose is clearly, as mentioned in this paragraph, that its purpose is to reduce the criminal activities, to optimize welfare distribution, and Your Lordship, to eliminate.
Does this reduce criminal
Yes.
activity?
You tell the modus operandi by which you can reduce the criminal.
So, by Your Lordships, by taking a
Or how you
preventive
could-
step.
How you could predict the commission of the offense.
Indeed, Your Lordship, coming to
And
the.
thirdly, whether it is foolproof.
Your Lordships, in this digital age, social media platforms have emerged as a stage of speech, as a primary stage for speech and expression, Your Lordships.
Your-
But one cannot deny that a single post or targeted misinformation can cascade into coordinated violence within minutes.
Something that you term as misinformation. Something that you don't see. My concern with this is understand it like this. My Lord asked a very pertinent question.
Indeed, Your Lordship.
We have seen in past This is AI age, AI, but there has been profiling in West and otherwise of people of color, people from certain communities. You are basically eating in the bias that already exists in the society.
Recently, the AI has been used by the Income Tax Department, and for its malfunctioning, an apology has been issued by the department because it has used harsh language, has given notices to those even who are not even violated any law or any regulation. So that is why whether this technology, AI, is 100% foolproof.
Your Lordship, we are not hereby claiming the infallibility of artificial intelligence
The
system.
question of
No, you are a union.
But you're collecting data.
Indeed, Your Lordship. Your Lordship, our contention here is simple. We have created a national digital governance platform which aims at reducing the discrimination, the human bias that inherently exists within human agencies who are working in the law enforcement agencies. Your Lordship, being humans, we tend to inherit the biases from our past experiences. And based on
I'm stopping right there. Paragraph 2. Although the technology developed it for city administration to forecast public service demands, optimize transport networks, and anticipate infrastructure maintenance need, you turn it all over and you bring it to social welfare distribution, law enforcement agency, predict potential criminal activity. This was supposed to for traffic management, a software for traffic management that now you are using for behavioral analysis, which you do not have the power to. Right? There is no law that is protecting this data. There is nothing that you are saying. You are saying you are not counting on the infallibility of it. If you know it is going to fail as a union, don't you think you should count on the infallibility? You should ensure the infallibility.
Your Lordship, this is what the union is consistently working to prevent. The union is ultimately aiming to create a foolproof system, but this is only the starting phase, Your Lordships. We have implemented this PrismNet only in 5 pilot cities.
Is it affecting the life and liberty of the persons?
Your Lordship, this
It
is
would be like that you are testing a medicine which has not even been tested on the animals.
Your Lordship. Your Lordship, the PrismNet is merely an instrument of calculating risk scores. Ultimate human agency is there which acts on it, and we believe, Your Lordship, the union believes that human agencies tend to inherit the biases, and PrismNet is only supplementing rather than supplanting that human
Now,
agencies.
supposedly you collect my data.
Indeed,
Now
Your
my
Lordship.
data is with you.
Indeed,
You
Your
say
Lordship.
that you are just working on 5 pilot cities.
Indeed,
That
Your
is what
Lordship.
you have. Now these 5 pilot cities do have hundreds and thousands of people, and their data is now with you.
Indeed, Your Lordships.
Now, if there is any kind of misuse, who will be responsible? Because your object statement and reason is totally different in paragraph 2 and paragraph 3.
And moreover, you are assisting the law enforcement agencies.
Indeed, Your Lordships.
In what way you would be assisting them?
Your Lordship, PrismNet tends to
You will provide all the personal details to the investigating agencies.
Your Lordships, PrismNet tends to provide an analytical data, and that analysis is based on the data that we collect, and ultimately the human agencies have to use that upon their discretion. The purpose of PrismNet is not to supplant the human agencies, Your Lordships. Here, it is merely supplementing it by providing such a data which is free from bias, free from discrimination, that humans being tend to inherit from their own past experiences. This is the sole purpose, and unlike the petitioner's claims that PrismNet is discriminatory and biased, this is the very bias that PrismNet tends to eliminate. And this is
Kavia writes, if we deploy PrismNet without rigorous audits, we risk institutionalizing discrimination. Algorithms are not neutral, which is a fact. They inherit the biases of the data and directives we feed them. We must implement regular independent audits and retain full transparency to safeguard citizen rights. There was a fear.
these are indeed
There were concerns. These are valid concerns. The person is not a layman.
indeed, Your Lordships.
What did you do? You arrested that person. A person who raised concern, you arrested them.
Your Lordships,
That
these
is the first instance of misuse.
Yes.
Exactly.
Yes.
Your
This
Lordships,
is what is going to be.
Your Lordships,
If whistleblower is saying something, you will arrest them.
Your Lordships, Dr. Kavia Iyer, being a member of the board, formally raised her objections to Prisminate,
Right.
and they were formally noted down for account and taken account of. But your lordship, because the board took a majority decision, we cannot say that Dr. Kavia Iyer was sidelined or her opinions were being sidelined.
No, she was just arrested
Your lordship,
under UAPA.
may the council clarify on the point. Dr. Kavia Iyer was not arrested for making a dissent. She was arrested for
For being
leaking
a whistleblower.
sensitive data of Prisminate as a national governance platform, your lordship. It was
So you are saying that the Prisminate has the protection of the state.
your lordship, Prisminate as a project is a part of a public-private partnership. So indeed, it has a protection of the state, but it is not, and therefore leaking the algorithmic audit reports or certain informations which are discrete and which are supposed to be, which are given in the hands of a person like Dr. Kavia Iyer. They have to be concerned. They should know what kind of data they have the right to release or not. And here Dr. Kavia Iyer was not in the position that she could release such, and that to your lordship, she released the data to a national daily, not used any authorized.
No. The data that was leaked was suggested that government officials requested real-time access to raw data and adjustment to risk parameters in key electoral districts, intensifying public concern and ethical security. This is like what is happening.
Your lordships, the data, this information released by Dr. Kavia Iyer, there are no facts.
This is all that she released.
Indeed, your lordship, but
And you went behind her under UAPA, under draconian law, for saying this much.
your lordship, the council would like to beg to differ here. The timing.
No, what are you differing from this? These are facts.
Indeed, your lordship, the council humbly refutes these facts to be.
These are admitted facts. You cannot refute
Your
them.
lordships, these facts were admitted by Dr. Kavia Iyer.
No. These are admitted facts. This is part. I'm reading from the compromise.
Indeed, your lordship, but it clearly shows that Dr. Iyer's leaked communications revealed. So these are the leaked communications of Dr. Iyer, and she
Yes.
being.
And what was leaked? Only this much.
Uh,
And you ended up doing what?
Your lordship, the council would like to make a clarification here that strategic timing in which Dr. Iyer leaked the communication makes it within the ambit of the sections
Why?
in which.
Are we close to any election? Because what you were asking for was specifically for the electoral district.
Your lordships, even though this issue will be dealt at depth by my co-counsel, I would like to make a small information here that
The co-council better deal with it.
indeed, your lordship, she will be dealing and clarifying how Dr. Iyer's conduct amounted to the
What
section.
Dr. Iyer has leaked?
Your lordship, as given in paragraph 20, she
Yes.
leaked information relating to Prisminate, which was supposed
What
to
information?
that Prisminate was the functioning of the
Internal
Prisminate.
communications? Internal communications?
Indeed, your lordship.
Then she has not or he has not leaked the personal data of the person which has been collected by this entity?
Yes.
It is.
Pardon, your lordship.
It is what is being stated. Only the internal communication has been and audit reports have been leaked.
Indeed, your lordships.
How does it violate the Confidentiality Act?
Yes.
Your
Or
lordship.
UAPA?
And
This-
what is this UAPA?
Your lordships, because of the paucity of time and the issues that
No,
I
you
will
have
be.
time, you deal with it.
Your lordship, this issue will be better and at length dealt with
How
my
this
co-counsel.
leakage of internal communication is going to affect the national security?
Your lordship, because there was already public upheaval around Prisminate. People were having apprehensions, and at a time when Dr. Kavia Iyer released this information,
Only
it is.
So people also had concerns.
Yes.
But your lordship, these concerns were
What
unfounded.
you are calling upheaval may just be concerns and valid concerns. These are our
Your lordship-
concerns as well.
Your lordship, because Prisminate was in a primary stage of its operation, and the concerns of people were based on allegations made on
Suppose
Prisminate.
there is a public movement and a genuine public movement, and a body and a person has supported that public movement by tweeting or by going on any social site. You will put him under UAPA
Your lordship, if it
because you are having an apprehension that it will ignite the situation.
indeed, your lordship,
And for what purpose these agencies are there?
these
For what purpose these land order agencies are there?
your lordship, ultimately the action which was taken by the law enforcement agencies only on
Is it
Dr.
a sufficient ground?
Is it a proportionate action?
Your Lordship, again contending this issue is a separate issue which will be dealt by my co-counsel and
Okay,
at length.
you in 1 minute, we will not interrupt you. For 1 minute, you just tell what your issue, what you are dealing with. Let us see.
Your Lordship, my first issue is Prisonette is not violative of the Constitution.
You are dealing with 21. And what we are placing for you, whatever our queries are, is it in the background of Article 21?
But Your Lordship, these queries specifically relate with arrest of Dr. Iyer, and my queries relate with the petition filed by People for Digital Liberty.
Council, you are arguing on 14, 19, 1A and 21.
Indeed, Your Lordship.
What
You
is
said
21?
issue 1, right?
Indeed, Your
14,
Lordship.
19 and 21.
Indeed, Your
21
Lordship.
pertains to arrest or pertains to personal liberty.
Indeed, Your Lordship.
Right?
But Your Lordship, again, the issue 1 relates with the writ petition filed by PDL, which relates to the fundamental rights of the citizens at
Where
large.
does it say that? Where does it say that?
Your
The
Lordship,
issue 1 it relates to PDL. Where does it say
the
that?
clarifications, Your Lordships.
Yes, please point out.
Clarification 9, Your Lordships.
Yes.
It says that the writ petitions have been filed by Aurora Technologies Private Limited,
Right.
Dr. Kavia Iyer,
Right.
and People for Digital Liberty,
Right.
while minority shareholders have filed a civil appeal.
It
And
says broadly.
broadly, issue 1 and 2.
Yes, not just broadly. It is not limited to that.
Your Lordship, but because PDL is filing the writ petition, it will be filing it for the interest of the people at large because it is a civil society organization. So considering that aspect,
Yes, yes. Continue.
should I continue with the...
Yes,
Yes, yes, continue.
Considering that aspect, Your Lordship, the council contends that in this issue, the fundamental rights, how Prisonette is not violating the fundamental rights of people at large is the contention of the council. Should the council proceed with issue 1, Your
Yes.
Lordships? Your Lordships? Your Lordships, in the first prong of the issue 1, the council contends that Prisonette there was a rational nexus plainly existing between the data processing by Prisonette and the twin objectives of national security and welfare delivery. Your Lordships, moving to the second prong of the argument that Prisonette did not intend to cause any blanket ban or restriction on the freedom of speech and expression. It was only a preventive measure to ensure public order and peace in a society, in a time when social media has emerged as a primary stage of speech and expression. And third, Your Lordship, petitioners claim that Prisonette fails the proportionality test, but the Council of Respondents humbly contests this. As to legality, data processing under Prisonette is expressly backed up by the EPDP Act. As to a legitimate aim, Prisonette serves the twin objective of crime prevention and welfare optimization. As to proportionality, Prisonette merely supplements rather than supplanting human agency.
Come to your memorial, page 16. I wanted to read this. The need for nationwide profiling, a facilitator of welfare and security. It is humbly submitted that Prisonette represents a necessary and constitutionally permissible exercise of the state's obligation to safeguard public welfare and national security. Human-led predictive assessment is inherently plagued by bias and unwarranted variability in individual judgment.
Indeed, Your Lordships. Human.
The data that you feed to this AI is also fed by human. And your main defense is that the final action is taken by human intervention. And while here you are saying that it is biased,
Your Lordship, but by Prisonette.
you are contradicting yourself.
No, Your Lordships. Your Lordships, the purpose of Prisonette was not the supplanting of human agency. It was only.
You are saying that humans are biased. Plagued by bias. Is your AI not plagued by bias because the data is being fed by humans?
Your
It is
Lordship,
being directed by humans.
Your Lordship, but AI works on.
And this is what Kavya Iyer also highlighted.
Indeed, Your Lordship. But Your Lordship, artificial intelligence systems are made to work on an algorithm. And when that algorithm is not biased, we cannot say that the data processed by it will be biased. And the allegations on Prisonette of being biased are mere allegations. There are no proof in the
How
factual.
does the algorithm work if not on bias?
Your Lordship, the council would not like to go into the technicalities because of the limited knowledge of the council. But Your Lordship, algorithms are
Algorithms feed on your biases always. For example, you take on a social media, let's say Instagram, and you're going through the reels. It will show you what you want to see, and the more time you spend on a certain reel, that subject matter, that is kind of reels you will start getting.
indeed.
So AI inherently works on your bias.
Indeed,
If you
Your
ask
Lordship.
ChatGPT about recently during the Iran war, before that, Claude and other AI, in every situation, they decided to nuke the country. In every situation, they work inherently on our biases, and they don't have the human morality to control those biases that humans inherently have. Here, what you are saying, that dependency on AI, saying that it is unbiased, that is completely scientifically and factually wrong.
Your Lordship, that is why we are not supplanting that with the AI completely. We are ultimately leaving the judgment. We are ultimately
Leaving the judgment to you are the state.
we are ultimately leaving it to the human judgment, Your Lordships, which is ultimately taken by the law enforcement agencies, which they have already been doing.
State.
But indeed, Your Lordship, the law enforcement agencies, Your Lordship. But
You want to say that ultimately the data is going to be analyzed and appreciated by human beings.
With
Indeed.
biases.
Which,
With biases,
which
as you just mentioned.
who may have biases.
that is where PrismNet comes into play, Your Lordship. PrismNet tends to eliminate those biases in the first stage.
What do you
And
think? The state must go by the doctrine of biasness or by the doctrine of necessity?
And I'll add also proportionality to that.
Absolutely.
pardon, Your Lordships,
See, state do have the responsibility.
indeed, Your
Right.
Lordships.
So whether you're governed by the doctrine of biasness or you're governed by the doctrine of necessity.
May the council
Yes,
seek,
yes,
I
you are
guess,
permitted for 2 minutes.
Your Lordship.
Respond.
See, you're a state, you're governed by the doctrine of biasness or you're governed by the doctrine of necessity.
With doctrine of necessity, for sure.
But it doesn't seem so.
Uh,
By your argument, it doesn't seem so.
the council begs to differ here again, Your Lordships. Your Lordships, here the petitioners have misread the entire purpose of PrismNet. PrismNet is not a agency of control. PrismNet is an agency of help to the human agency. Here, PrismNet is merely calculating risk scores, and it is eliminating the primary bias that human beings might have from their past experiences. And by eliminating the bias from the data, it is giving that data to the human agency to make the ultimate judgment, Your Lordships. This is the ultimate contention of
Ultimately, a decision is to be taken by a human being.
Your Lordships. But when the PrismNet tends to
Who,
eliminate,
according to you, was biased.
Your
Was,
Lordship,
stroke is biased.
Your Lordship, by that logic, all the decisions that are being taken would have to be challenged. But this is a step where we are trying to change that. PrismNet is a step through which we are trying to eliminate that bias, and this is the mere contention of the
And then
council.
arrest the only person who raises a doubt about it.
Your Lordship, again, the arrest was
One may say that you are acting as the agency of that biased person who has to take an ultimate decision. Because he cannot collect all the data, you are feeding him. You are feeding a biased person.
Your Lordship, PrismNet is not merely collecting data. It is collecting
Collecting and providing, it is your object.
and analyzing that data to ensure that it does not remain biased in a way that it will affect the
Whatever you are
decisions of the
doing,
law
you are
enforcement
placing it
agencies.
in the hands of a biased person.
Analyzing.
You yourself had said that they were biased, therefore you are adopting this technology.
Your Lordship, again, the state would, the council would, for the respondent contends that PrismNet was a mere supplementing the decision, supplementing the human agency and not supplanting it. And its purpose was ultimately to reduce the criminal activities and to improve the welfare delivery measures. It is not ultimately just a. May the council seek an extension
1
because
minute.
two issues are remaining.
Just 1 minute.
Your Lordship, but the
Will-
council is
will-
only.
will-
You need not complete your issues. We are aware of the issues. We have read the brief.
Indeed, Your Lordship, much obliged. Pardon, Your Lordship, which issue should I continue with?
Whatever you were saying, just
Whatever you
complete that.
Indeed, Your Lordship. Your Lordship, in the submission for the issue, ultimate objective of PrismNet, again, the council would like to submit that Prismnet was not created with an objective of mere surveillance or merely labeling people as a risk, labeling the risk parameters of people. Its objective was not mere criminal activities. Its objective was also welfare optimization. We see there have been leakages in the subsidies, the schemes. So to ensure that such leakages are being controlled, we need to do the profiling to ensure only the bona fide members of the society are give and the deserving members of the society get what they deserve. And this was the sole objective of Prismnet, to facilitate the human agencies rather than rather than supplanting it. Its aim was merely to ensure a more efficient and a better system which is free from bias, discrimination, and working efficiently for the welfare of the people.
Thank you.
Much obliged, Your Lordships. It was a pleasure arguing before the honorable bench.
Yes.
Greetings to the honorable bench. This is the second counsel appearing on behalf of the respondents. Your Lordships, the council seeks permission to begin with the third issue, that is, whether the EPDP Act is constitutionally valid. Much obliged, Your Lordships. It is humbly contended that the EPDP Act and its provisions are indeed constitutionally valid. Your Lordship, the council bases this contention on a three-pronged argument. First, the Act effectively safeguards informational privacy under Article 21. Second, the regulatory powers granted to Data Protection Authority of India is structured, purpose-driven, and fully compliant with Article 14. And lastly, the penalty and license suspension under Section 37 are lawful, proportionate, and constitute reasonable restriction under Article 19, Clause 6 of the Constitution of India. Moving ahead with the first prong of my arguments, Your Lordship. The EPDP Act satisfies the Puttaswamy tripartite test of legality, legitimate state aim, and proportionality. On legality, the EPDP Act is a duly enacted statute expressly establishing clear legal authority for data regulation. On legitimate state aim, Your Lordships, protecting citizens from data misuse, ensuring accountability of private entities like Aurora, and regulating emerging AI technologies is indeed a compelling state interest. And Your Lordship, on proportionality, there are certain sections of the EPDP Act, such as Section 6, which mandates free and informed consent. Section 4 of the EPDP Act imposes purpose limitation and data minimization. Section 8 requires reasonable security safeguards. These provisions, Your Lordship, are collectively reflect carefully calibrated mechanism and not generic provisions. Your Lordships, Aurora.
Do you not think that these acts and your actions really do constitute to violate Article 14 and 19? It will have a chilling effect if the state is listening to conversations and profiling on the basis of what I feel on social media, what my ideology is. Don't you think, given how powerful you are, it will have a chilling effect on freedom of speech?
Your Lordship, the Council respects Article 14 and 19 and the right to freedom of speech,
you
but
your client probably doesn't.
But there are reasonable restrictions under Article 19, Clause 2, Your Lordship, and the state.
Reasonable restrictions for a reason, but this is now you are going in the overbreadth of it. Matter of fact, you suspended Aurora's license without any hearing, right? You did that?
No, Your Lordship.
You haven't suspended Aurora's
Your Lordship, under Section 33(1) of the DPDP Act, it states that it empowers Data Protection Authority to impose monetary penalties after inquiry and giving person an opportunity of being heard. It clearly follows the principles of natural justice, Your Lordship.
But you did not.
We did, Your Lordship. There are no claims raised anywhere that we did not.
The Authority of India launched suo motu proceedings in December 2025 against Aurora Technologies under EPDP Act. The allegations included unauthorized transfer of citizen data to foreign collaborators, failure to conduct mandatory algorithmic bias audits, and inadequate safeguard against internal and external breaches. Subsequently, the DPI levied a 950 crore INR penalty and suspended Aurora Technologies' data processing license without any hearing.
Your Lordship, the Data Protection Authority of Indica is a body which has been formed by the EPDP Act itself, and thereby it does comply with the provisions of its own act, parent act. Therefore, Section 33(1) of the EPDP Act clearly it empowers how this proceedings, how this procedure is to be carried about. It empowers DPAI to.
Without giving any opportunity of being heard to the party against whom you are going to take a decision. We are having certain natural justice principles.
Yes.
Principle of natural justice is to be followed.
Your Lordship,
We are hearing you, and then we are making our mind. Without hearing you, how we can gauge how you are arguing, how you are prepared. It is like that. Without giving you an opportunity to argue, we should assess and give the marks. It is not so. This is the basic natural, the principle of natural justice, to provide an opportunity of being heard to the party against whom you are taking a decision.
Your Lordship, the proceeding which was carried it was carried out for determining the monetary penalties.
Extends to the administrative action also.
Indeed, Your Lordship. Your Lordship, these monetary penalties are determined on the basis of significant data breaches. And these significant data breaches have been clearly defined that what is a significant data breach
Your
in a...
case, that person, the gentleman or gentlewoman against whom you are proposing some action, he or she will have to respond to your allegations.
Your Lordship, the
Then
respondents...
it would be for you to take a decision. Without affording him any opportunity, how you could take a decision?
Your Lordship, the respondent's sole contention here is that the penalties imposed and the license suspension.
How you could impose the penalty? The question is this.
Counsel, first you are responding, you should respond instead of looking at that.
Pardon, Your
What you
Lordship.
were saying.
Pardon, Your Lordship. I was saying that the respondent's sole contention here is that the monetary penalties and license suspension constitute a reasonable restriction on the under Article 19, Clause 6, because, Your Lordship, the DPAI has followed the provisions of the EPDP Act very well. It has not conducted arbitrary proceedings over the petitioners. It has very well complied with the Section 33 subsection 1 and Section 33 subsection 2. Section 33 subsection 2 clearly states that, Your Lordship, it clearly eliminates arbitrariness, Your Lordship, by mandating structured considerations of breaches nature. By breach, I mean the significant data breaches, Your Lordship. The breaches nature, gravity, duration, volume of affected individuals, data sensitivity, repetition, mitigation efforts, and intent. So, Your Lordship, all these criteria are very well framed objective criteria. They are not subjected to any subjective interpretation. Therefore, Your Lordships, this entire proceeding, the arbitrariness is structurally eliminated from this proceedings, Your Lordship.
All right.
Moving ahead, Your Lord.
You are also going to deal with the arrest, right?
Indeed, Your Lordship.
You are right. Okay.
Uh,
Continue.
Continuing with the third issue, Your Lordship.
Yes.
Moving to, due to paucity of time, moving to the last prong of the argument, Your Lordship. Your Lordship, when we apply it to the facts, Aurora here was entrusted with the personal data of millions of citizens. It breached that trust systematically, repeatedly, and deliberately, Your Lordship.
They were in CPP with you.
Your
They were
Lordship.
complying with your directives. Matter of fact, they are in their shareholding meeting, they insisted on complying by 4:1. by
Indeed, Your
complying with
Lordship.
directive. So what you are alleging on them was basically your directive.
Your Lordship, government directives were given for policy outcomes and for the operational efficiency of the AI tool, that is
And
PrismNet.
they followed that.
Government
They're voting on
directives were not given regarding the infrastructural and technical aspect, Your Lordship. The algorithmic aspect, Your Lordship, remained in the hands of Aurora. You can, if Your Lordships may please refer to page 2 of the Moot proposition.
You page 8, sorry, paragraph 8. Throughout 24 and 25, Aurora Technologies received several formal communications from the MODA, emphasizing strict compliance with the government instructions. A letter dated 10/3/24 stated Aurora Technologies is directed to ensure that business analytics are aligned with policy priorities. Real-time data sharing with designated government servers is mandatory. Any delay in compliance will be treated as a breach of PPP contract. That's first. Then an internal email from Minister of Digital Affairs to CEO. Operational success of FISNet is critical to national security and public administration. Board dissent must be resolved internally. Must be resolved internally. Adjustment to algorithmic outputs are permitted under government directives and are expected to be implemented without delay. You are putting repeated pressure, and there was no instructions on your part. While you have given repeated instructions on compliance, on doing it quickly, for following the government mandate, you did not give any direction for them to comply with the law.
Your Lordship, we did give. Please refer to page 2 of the Moot proposition, Your Lordship. Your Lordship, para 4 clearly states that the project PrismNet was to be executed through a PPP agreement, and Your Lordship, there were the government said that there has to be mandatory compliance with national digital laws such as the EPDP Act, Your Lordship, which we hereby say that the EPDP Act is constitutionally valid. It is the Aurora technology which was non-compliant with the statutory obligations of the EPDP Act, because they are
But
the
you are
petition-
representing Aurora as well.
No, Your Lordship. Here, the present council is representing the Union of Indica in both the issue 3 and 4, Your Lordship.
But I think our lawyer friend did inform that they are paying, you all are paying for Aurora as well.
Your Lordship, she was, in her case, it was PDL versus Aurora Technologies. Your Lordship, this, the issue 3 and issue
given
4.
the cost title in our 32 petition. But anyway, proceed.
Your Lordship, to be precise, the present council is dealing with issue 3 and 4, and the present council represents Union of Indica in both of the cases. And regarding that clarification, Your Lordship, the government mandated Aurora Technology to strictly comply with national digital laws, which they failed to do. Also, Your Lordship, regarding the directions which you were talking about, the government was giving them directions regarding operational efficiency and policy outcomes. But and also it allowed Aurora Technology to retain intellectual property rights for its algorithms, which means that the technical aspect and the algorithmic infrastructure aspect was to be dealt with by the Aurora Technologies itself, and not through the directions of the government, Your Lordship. Moving ahead with the arguments, Your Lordship. Regarding the penalties, Your Lordship, so therefore, Aurora was entrusted with the personal data of millions of citizens, and it systematically breached its obligations. Your Lordship, Aurora's own board resolution acknowledged constitutional risks in its own operations, which means that Aurora knew its obligations. But nevertheless, Aurora
Yes, they
chose.
knew, and then
Indeed, Your Lordship,
yes, they say that that's why
they knew about their
Ms.
obligations.
Iyer says complying with government instructions may compromise the integrity of our algorithms and violate
Indeed.
constitutional privacy rights.
Indeed.
The company must establish safeguards to ensure ethical compliance while fulfilling contractual obligations.
Indeed.
Despite her objections, the board passed a resolution for one to comply with government directives, formally noting Dr. Iyer's dissent. Before that, you have written multiple times, do it quickly, these are the directives. While those are not in public domain, all this urgency, all this waiver of the objection of Dr. Iyer were because of you.
Your Lordship, firstly,
You, matter of fact, wanted to wanted to change a software that was to optimize transport network and turn it into for predicting potential criminal activity. It was your directive. It was your objective.
Your Lordship, the intentions behind PrismNet initiative was never malified, Your Lordship. The sole intention behind the initiative of PrismNet was law enforcement and the distribution of social benefit schemes. It is Aurora Technologies which failed to comply with the mandatory statutory obligations under the EPDP Act, and due to its non-compliance.
Specific, compliance.
Indeed, Your Lordship, the council will. Your Lordship, the statutory obligations which are documented here are unauthorized cross-border data transfer under Section 16 of the EPDP Act, failure to conduct periodic audits under Section 10, and inadequate security safeguards under Section 8. Aurora failed to meet all these three statutory obligations, Your Lordship.
All right.
Moving ahead, Your Lordship.
deal with issue 4.
Indeed, Your Lordship. Issue 4 states that whether the arrest of Dr. Iyer under Section 3 of the NSCA, Section 147, 148, 150, and 152 of INS, and Section 15, 16, 18 of UAPA was lawful, and the Council here strongly contends that the arrest was indeed lawful. Your
Counsel,
Lordship, the Council.
I will stop you for a moment. Paragraph 20. Her disclosures were limited to 3 things. Government request to recalibrate algorithmic risk scores for a specific district, which is again illegal on your part because you're asking for electoral for the electoral districts. Second, instructions for unrestricted access to sensitive citizen data. You should not have that data. Third, board disagreements over ethical and constitutional compliance, including her own dissent. She only leaked these 3. You arrested her under National Security Confidentiality Act, NSA, Nyaya Sanhita,
Indeed,
and UAPA,
indeed, Your Lordship.
draconian law. Don't you think your action is disproportionate?
No, Your Lordship.
No, it is. It is. The objective of UAPA was to deal with terror activities. Does her dissent, her disclosure constitute any terror activity?
Indeed, Your Lordship. Your
How?
Lordship, Your Lordship, this court has unequivocally held that terrorists' acts are not confined to bombs or conventional
Right.
weapons.
Was she instigating?
Not confined
Did she
to.
instigate anyone?
Oh.
Did she instigate? Did her leaking these communication cause any terror activity? First, any movement of any sort, any dissent, anything?
Indeed, Your Lordship.
Her arrest caused the strike. Your action caused the strike. Your action caused the disturbance of public order. It all happened after her arrest. Until then, there was no law and order issue.
Your Lordship, if you may refer to page. Your Lordship, if you may refer to page 4 of the Moot proposition,
Yes.
8 months before her arrest, by March 2025, PrismNet's risk scores were public. Para 12, Your Lordship.
Yes.
By March 2025, which is 8 months before her arrest, PrismNet's risk scores were publicly criticized for disproportionately flagging low-income marginalized neighborhoods. Therefore, Your Lordship, it was not the arrest of Dr. Iyer, Your Lordship. It was not the arrest of Dr.
This is exactly what we are saying. You have actually, by referring to this, just killed your case.
Your Lordship, the public unrest was already existing there. It was not the arrest which caused the national level
These
strikes.
were concerns. Concerns are a separate thing. Actual law and order problem is a different thing, which happened after you arrested her under draconian law for only stating dissent. And this is what our concern with this whole action is, with this PrismNet is also, because you have the power and you use it disproportionately.
Your Lordship, we invoked section 15, 16, and 18 of UAPA because
What is this?
Let's see what it is.
because Dr. Iyer very clearly satisfies the essential ingredients of these sections, Your Lordship.
Terrorist Act.
Your Lordship,
16, 18,
Yes.
definition is terrorist act. Whoever does any act with the intent to threaten or likely to threaten the unity, integrity, security, economic security, or sovereignty of India, or with the intent to strike terror or likely to strike terror in the people or any section of the people in India or in any foreign country by using bombs, dynamites, or other explosive substances. Which 15, which clause? Tell me.
Your Lordship, if you may,
See,
Section
clause
15.
15A is by using bombs, dynamites, etc. B, overawes by means of criminal force or the show of criminal force, does not apply here. 3, detains, kidnaps, or abducts any person, not the case here. All right. Then how under 15 you have arrested her? Which clause under 15? Neither A, B, C, none of that.
Your Lordship, if you may please refer to page 77 and 78 of the compendium, Your Lordship, as held in the case of Gulfisha Fatima versus State NCT
I'm
of
quite aware
Delhi.
of that.
Uh, Your Lordship, Section 15's expression by any means, whatever nature, it cannot be rendered futile.
That is a case related to the Delhi riot, where there were actual deaths.
Your Lordship, not strictly aligning with the facts and coming to the
Today,
principles.
Gulfisha Fatima is on bail, granted by us.
Your Lordship, the petition, the
That
council
case
here.
was limited to the facts of that case. We did not lay down any law in there.
The council here is not
Whether
taking
the-
that.
Whether the observation was after trial, whether she was convicted, acquitted, or it was with regard to the grant or non-grant of bail.
Yes, it was just bail.
Your Lordship, a clear.
If it was with regard to grant and non-grant of bail, it may not have any effect on the trial.
Your Lordship, a clear principle was upheld in this case that
Observations made
Which
either for granting bail or non-granting bail is useless so far as the trial is concerned.
this was a bail hearing. We did not lay down any law. You cannot rely on this.
Your
This was
Lordship,
limited to that fact.
Yes.
And there were people who died, and today Gulfisha Fatima was granted bail few months ago by us.
Your Lordship, the council here is not taking the facts of Gulfisha Fatima as an analogy.
You are
As
citing
a,
a criminal
principle at all.
case.
It is not a principle at all.
There's no
You know, in criminal law, a person could only be convicted if the state or the prosecution has proved its case beyond reasonable doubt, which is not a case when granting or not granting bail.
if your Lordships may
It is-
please
it
refer to
cannot be
page
used.
77 of the
Counsel, it
compendium.
cannot be used as precedent.
Your
Any
Lordship,
observation bowl, every order of bail is qualified that it will not have any effect on the trial. It is inherent, understood by the superior courts as well as by the trial courts.
Page
your
what?
page 77 of the compendium.
Where's the compendium?
Your Lordship, the compendiums have been submitted.
We don't have it. But what
So
can you
may
tell about
may
this
the
item?
council read what is there on para 88 page 77 para 88, your Lordship.
Page 77, what it says.
The consequences contemplated under section 15 further illuminate the legislative understanding of terrorism, your Lordship.
Yes.
Apart from death or destruction of property, the provision expressly encompasses acts which disrupt supplies or
Right.
services essential to the life of the community,
Right.
as well as acts which threaten the economic
Right.
security of the
Now,
nation.
Basically, your act of arrest caused this. Before that, there was no threat to any supply. Don't tell me something. Before her arrest, was there a public order disturbance?
Your Lordship?
Clear yes or no? It's a clear yes or no answer.
No, your Lordship.
No. Did her arrest cause that?
No, your Lordship.
It
Let
did. You-
let
please
the
read
council, please let the council explain, your Lordship. Your Lordship, it was not the arrest which caused the public unrest, protest and strikes. It was the disclosures which the Dr. Iyer made to the
No,
national.
ma'am.
Indeed, your Lordship,
No.
you may please refer
Owing
to page
widespread
7.
coverage of the issues, nationwide protests and strikes were held after Dr. Iyer's arrest. She was arrested from her home on 22/11/2025, paragraph 21.
The issue which, owing to the widespread coverage of the issue which is being dealt here is the disclosures which she made to a national daily. Indeed, your Lordship also, Dr. Iyer did not choose a legitimate channel to leak such sensitive
What was the
data.
legitimate channel with her? She did raise the issue in internal board meetings.
Your
She was
Lordship,
steamrolled by 4-1, whatever she said, the resolution was passed because there was money involved, 100 crore rupees was being funded.
your Lordship,
Matter of fact, there were issues with the minority shareholders as well.
your Lordship, before
And you were
releasing,
putting pressure on them while also changing the whole idea of that software.
your Lordship, before releasing such sensitive citizen data and algorithmic
Did not
audit
release
reports,
them.
she
Did
did
not release
release
them.
algorithmic audit reports, your Lordship, as mentioned in the facts of the case.
What
If
does
you,
that mean?
this means that she released the algorithmic infrastructure, your Lordship, which is a
Algorithmic
confidential data.
infrastructure.
Algorithmic infrastructure of a national
Of a
surveillance
company,
framework.
of a company, of a software.
Indeed, Your Lordship, and that
The
software was.
represents national security now.
No, Your Lordship, the council here is contending that the motive behind PrismNet was for law enforcement, and therefore it was a national surveillance framework, Your Lordship. And Dr. Iyer, by releasing the algorithmic infrastructure of PrismNet, which was indeed a confidential information, and that too to a national daily, this is what lead to the why.
Right?
Indeed, Your Lordship, confidential information is not meant to be. National Daily is not a legitimate channel to
Can you just
disclose
tell me
confidential
something? If
information.
You had a PPP model with Aurora. She worked for Aurora. Whatever data or whatever issues that she raised or leaked were pertain to Aurora. How do you come into picture with the national security in this?
Your Lordship, the government's sole contention here is that, firstly, Dr. Iyer had the access to some certain confidential information due to her position in the company, because she was the board director. She had access to certain confidential government information, and because she unauthorizedly disclosed that communication. This is what attracts Section 3 of the NSCA, Your Lordship. Your Lordship, Section 3.
You convince us on 15, 16, 18 of your IPA.
Indeed, Your Lordship.
15 you have failed. You have bitterly failed to convince us on 15. There's nothing, not a single clause under 15 that could be raised against this lady.
Your
How is
Lordship,
it concerned with the national security?
Your Lordship, the council begs to differ here. Section 15's expression by any other means whatsoever, apart from direct.
Read. No, it's not limited to any other means only.
Your Lordship, not limited to. Your
It-
Lordship,
the
section.
term is terrorist act. Understand
Indeed, Your
the
Lordship.
value of it, the gravity of the word, the phrase. You cannot use terrorist activity for any and every dissent.
Your Lordship, it was not a mere dissent. Had she been a responsible whistleblower, we would not have invoked such anti-terror statutes against
What
her.
were you reading in 15? What did you just say? Before I cut you? Whoever does any act with intent to threaten or likely to threaten the unity. Okay? This is where you were? 15 UAPA?
Indeed, Your Lordship.
Again, A, by using bombs, not the case. Death, no. Loss of or damage to destruction of property, no. Disruption of any supplies, no. Damage to the monetary stability of India by way of production or smuggling of circulation of high quality counterfeit, no. Overalls by means of criminal force or the show of criminal force, no. Detain, kidnaps or abduct any person, threatens to kill, no.
Your Lordship, if you may please refer to Section 15, subsection 1, subclause A, by using bombs or any other means whatsoever. In last line, Your Lordship, or any other
Cause or
means.
likely to cause death, loss, disruption, damage or destruction of any property. You can, how are you reading the clause?
Your Lordship, the council here is contending that Section 15 does not confine itself to direct warfare activities. It also includes
But it
any
has to
other
be-
means, which means the tendency to invoke such public unrest and disorder, Your
Yes, ma'am,
Lordship.
But you cannot go beyond what is in Section 15.
Then your case is that whatever she did was having an indirect connection or indirect nexus with these activities, not the direct connection.
Your Lordship, the
These
judiciary.
activities, what has happened thereafter was not the direct result of her revelation.
Indeed, Your Lordship. Your Lordship.
How could you?
Your Lordship, the
How you could invoke these laws?
Your Lordship, the judiciary is expected to interpret the statutory provisions and hereby in
Are
good
you
wishes.
telling us our limits?
No, Your Lordship. No, Your Lordship.
Okay, continue.
Your Lordship, it's Your Lordship, as I've been saying.
Are you aware what she did? Read
Pardon?
paragraph number 20.
You read.
Of the Moot proposition, Your
Yes.
Lordship.
These are the only allegations. Read it.
Alarmed by repeated government directives and board compliance, Dr. Iyer leaked internal communications and algorithmic
Just a minute.
audit.
What she did? She did internal communication.
Indeed, Your Lordship.
How these communications are going to affect the integrity or the of the security of the country? Just a minute. Read further. Respond thereafter.
Oh.
And
and algorithmic audit reports, Your Lordship, as has been
keep this word
justified.
in your mind while responding to
Indeed.
or defending your action.
Indeed, Your
Now
Lordship.
come forward.
To a
Come forward.
leading daily, the Indica Observer.
Yes. Her disclosure revealed the following.
Government request to recalibrate algorithmic risk scores
Is it
for
not the truth?
Your Lordship.
It is truth.
It is what has been claimed by the.
No, it is truth.
It has been claimed.
Are you denying this, and do you have any basis to
Yes.
deny this?
It is what the government was doing for selected districts, to which you have termed as pilot project.
You have never denied this. Nowhere have you denied this.
Your Lordship, this particular contention was denied by my co-counsel in her issue 1.
Deni-
And the
You did not
present
undertake this exercise.
of exercise
This,
of.
what has been given in one government request to recalibrate algorithm risk scores for specific districts.
Your
What we
Lordship,
have- what we have learned, you have said that it was a project confined to certain districts.
Your Lordship, there are no substantial evidence in the facts that the government recalibrated risk scores for specific districts. These are mere allegations on behalf of the petitioners, Your Lordships.
Now come to second.
In
Come to second.
Beyond
Come
the
to second.
proposition.
Come to second. Instructions for
unrestricted access to sensitive citizen data, Your
is it
Lordship.
not the truth?
Your Lordships,
What
these
we
are.
what we are sensing. You are putting a person in jail because she has spoken truth.
Your Lordship, we are putting a person in jail because
Because
she
she is a broken
satisfies
code.
the essential ingredients of the statutory provisions of INS, NSCA, and UAPA. Your Lordship, she satisfies Section 3 of NSCA very clearly because Section 3 of the NSCA penalizes unauthorized communication of information entrusted in confidence by virtue of a government contract, here in PPP agreement. Your Lordship, Dr. Iyer, as a co-founder and board member, had access to sensitive operational data. This makes her arrest lawful under Section 3 of NSCA, Your Lordship, because she unauthorizedly,
You know,
legally.
we are dealing with an issue of personal liberty. Nothing more may be dear to anyone than the personal liberty. And simply on the basis of these 2-3 things, you are putting a person in jail. And in that case, where he cannot perhaps claim the bail for years.
Your
Do you have
Lordship,
any idea of
Your
the
Lordship,
gravity of the situation?
Your Lordship, the gravity of the
You are
situation.
not simply charging him in under any section of the IBC.
Your Lordship, the council indeed is understanding the gravity of the situation.
And you must have something more, something very special, something very dangerous.
Your Lordship, it is the very conduct of Dr. Iyer itself, which is putting her in the within the ambit of the essential ingredients of these sections of INS and UAPA, Your Lordship. Your Lordship, section 147 and 148 of the INS, these sections.
Leave that aside. What is this 147, 148?
Your Lordship, section 147 and 148, Your Lordship, these sections do not, as per the contention of the respondent, these sections do not merely confine themselves to direct warfare activities, but also include indirect methods such as financing, planning, and promoting anti-state activities, Your Lordship. Your Lordship, Dr. Iyer, as a co-founder and board member, was fully aware of national security dimensions of PrismNet, Your Lordship. Yet, she made a deliberate move to disclose such sensitive national security infrastructure to a national daily.
National security came in.
Your Lordship?
From where you are guessing this national security?
Your Lordship, the very bona fide motive behind PrismNet was
Whether
law
it was in
enforcement.
The objective for which this collaboration was done? What was the objective? When
Behind-
you entered into with this, when the state entered into with the agreement with the prison, what was the object of
The main bona fide objective behind
what were
PrismNet,
those objectives?
it was for law enforcement and for the distribution of social welfare benefits, Your Lordship. And as has been dealt by me in issue 3, Aurora Technologies failed to comply with the EPDP provisions, which is why the rights of the citizens have been violated. Therefore, the problem does not lie in the EPDP Act or its provisions. The problem lies in the non-compliance by the Aurora Technologies of these specific statutory provisions of Section 16, Section 10, and Section 8 of the EPDP Act, Your Lordship. Much obliged, Your
Any other
Lordship.
thing?
Your Lordship, coming to the INS sections, the present case satisfies both the tests of calculated tendency and proximate relationship recognized by. May the council conclude in 2-3 minutes?
1 minute.
1 minute, because we have already granted you some exception.
Much obliged, Your Lordship.
You are not aware of that. Yes.
Concluding, Your Lordship, personal liberty under the Constitution is not absolute detachment from state security. Sovereignty, integrity, and security are constitutional values which Parliament is entitled to protect through certain specific statutory frameworks, and this Honorable Court is duty bound to give them full effect. Thus, Your Lordships, it is humbly contended that Dr. Iyer's arrest was lawful, justified, and it must be upheld. If Your Lordships are satisfied with issue 4, the Council seeks permission to proceed with the prayer, Your Lordships.
Not required. We have already seen.
Thank you.
Thank you.
Much obliged, Your Lordship. It was a pleasure arguing before the Honorable Bench.
Thank you.
We don't have the score sheet. for that.
Yes.
So it will, it will be to no end. It won't serve any purpose. No, we don't have score sheet for that. And anyway, rebuttal, I don't think in any mood is scored on. You do for your satisfaction, that is one thing, but we don't score on rebuttal anyway. It's not required.
Because we
We
do not have any
also
column
have-
for that. What is
No point.
we have already recorded.
we have heard you at length. Absolutely.
So if you want to
Let us go
do
over
it for your satisfaction, you can do. Otherwise, it has nothing to
It
do
has
with the,
nothing, it will
with
have
the
no effect.
marks. But we do not have any.
No, you reserve time for that. I understand that. First of all, there may be in that, but again, our discussion prevails. A, B, it is not required because we have heard you at all at length. Not at all. None at all.
T26, no? And T27. What is the port number? Nils? Finance. Finance.